More than half of UK ad spend is expected to be online in 2015. That's according to a Group M report. With more than half of that £8.1 billion spend expected to be spent on paid search marketing, it's really a growing and significant area of ad land now. My name's Theo Savvides, I'm a partner at Bristows, and I'll be focusing this discussion primarily on the paid search element of online marketing, and in particular I'll be focusing on the interplay between paid search and trademark law. Just in terms of what I'm going to cover today, I will cover four main areas. I'll first of all set the scene by setting out some of the basics of paid search for those of you who aren't paid search experts. Just something around the mechanism on paid search and what brand bidding is, which is what I'm going to be really focusing on here. I'll then summarise what the European Court of Justice has said when it's been considering whether brand bidding can amount to trademark infringement or not. I'll then go on to explain how the English court has implemented what the European Court of Justice has said, and that will be really by focusing on one particular case, the case of Interflora against Marks & Spencer, which has been through both a first instance judgment and now an appeal judgment that was handed down in October of this year. Finally, I will cover some of the considerations that both advertisers and trademark owners may want to take into account when adverts are appearing on a trademark search term, on a search engine results page for that trademark search term. So first of all, how does paid search work? Well, just to explain at the very basic level what paid search is when you get an advert appearing, when you enter a search term into your search engine. So for most people, that's probably going to be Google. That ad is delivered as a result of an advertiser selecting what's called a keyword, and that keyword will trigger the advert to appear on the search page when the search term that the internet user enters has some relevance to that search term. Getting into some of the specifics of paid search, as I mentioned previously, the keyword has to have some relevance to the search term. The extent of the relevance will really come down to the match that the advertiser has placed on the keyword when he is entering into the whole AdWords system. The mechanism by which the advert is delivered onto the search page is really dependent upon the breadth of match that the advertiser places on the keyword that he selected relative to the search term that the internet user enters into the search engine. There are three types of match: exact match, phrase match, and broad match. Exact match really does what it says on the tin. It effectively matches the keyword against an exact match entered into the search term. A phrase match is where there are one or more words appearing in the same order in the search term that match the keyword. In those instances, there can be other words either before or after the phrase that the advertiser has bid on. And then finally, there is broad match, and broad match effectively covers plurals and variations that appear on the keyword anywhere in a string of words in a search term. It can also cover words that are conceptually similar to the keyword. So by way of an example, if an advertiser bids on the term florists, if the word flowers is entered into a search term, it may well be that the ads of that advertiser are still put up onto the search page by the search engine operator. The one thing to bear in mind relative to both phrase match and broad match is that there is also something called negative match. And what that does is it enables an advertiser to ensure his ads aren't delivered if a particular word appears in the search term, string of words at the search term that the advertiser puts into the search engine. An example of where that might be the case is if an advertiser wants his advert to be delivered in response, say, to a search term for roses, he wants to advertise the roses he's selling, he wouldn't necessarily want his advert to be delivered where somebody was searching for the pop group Guns N' Roses, for instance. So in those instances, he'd negative match the word guns just to make sure his ad didn't appear in relation to those search terms. So what's the relevance of brand bidding to all of this? I suppose the key thing is to understand what happened in 2008, first of all. That was quite a significant policy change by Google in terms of trademark owners at that time. Google basically enabled advertisers for the first time to be able to select keywords that were actually trademarks in those circumstances and to have their ads delivered where internet users entered search terms for those trademarks effectively. First of all, I'm going to deal now with what the European Court of Justice's view was in terms of whether brand bidding is trademark infringement or not. The first thing to bear in mind is that the European Court of Justice made it clear that there is nothing inherently objectionable in brand bidding as such. Consequently, a trademark can't be used to prevent what they characterised as fair competition. The issue is, however, whether the advert is what they would see as fair. There are a number of nuances to the analysis based around what the European Court of Justice analyses when it considers trademark infringement around the functions of a trademark. There has to be an effect on one of the functions, and there are a number of functions of a trademark generally for there to be trademark infringement. There are also considerations around marks with a reputation as well, where again sometimes in trademark law there can be a number of other factors that come into play when considering trademark infringement. Ultimately, these nuances came back to the same thing, I think, as far as the European Court of Justice was concerned. And ultimately, their main consideration here was whether the origin function of the trademark, which is the fundamental function of a trademark, it was whether that function was going to be affected by the advert in the context of the search engine results page where an internet user had entered the trademark term and that had caused the advert to be delivered. So the test that the European Court of Justice laid down when considering whether the origin function was going to be affected came down to a test that I will term as the reasonable internet user test. And what they effectively said that a court had to assess when considering trademark infringement in these circumstances was whether the sponsored link that was delivered once the keyword had been triggered by the search term, it was whether that sponsored link did not enable the average internet user or only enabled them with difficulty to ascertain whether the goods and services that were referred to in the advertisement originated from the trademark owner or an economically linked undertaking to the trademark owner, or on the contrary, originated from a third party. Consequently, advertisers will be liable for trademark infringement if the ad does not satisfy that test. I'm now going to turn to how the English courts have interpreted what the European Court of Justice have said, and most particularly how they have implemented the reasonable internet user test. As I mentioned before, this has primarily been through a case called Infringe against Marks and Spencer. Most of you will have heard of both of the parties in this case. Marks and Spencer is the very well-known high street retailer, and Infringe is very well known for the services it provides as a relay flower delivery network. Marks and Spencer, when the Google policy was relaxed in 2008, started bidding on the Infringe trademark as a keyword. Consequently, the Marks and Spencer advert was being delivered when internet users were entering Infringe into their search engines. The ad featured the marksandspencer.com URL. It also featured the M&S branding very heavily. Importantly, it didn't include the word Infringe actually in the ad text that was delivered as well. The English courts gave their initial judgment, the first instance judgment, in 2013. This judgment ultimately went against Marks and Spencer. Marks and Spencer appealed it, and the appeal hearing was heard in 2014, and judgment in the appeal was given in October. I'm going to first deal with what the Court of First Instance dealt with by way of findings of law in considering whether there was trademark infringement or not. The first key finding that the judge made at first instance was that in instances of keyword bidding, when considering the reasonable internet user test, there was a reverse burden of proof. Consequently, the burden of proof fell on the advertiser to show that his advert satisfied the reasonable internet user test. The other thing that the judge said was that in considering the reasonable internet user test, there needed to be a consideration of whether there was any initial interest confusion. Initial interest confusion is a particular doctrine that is considered at times in trademark infringement, and what it effectively says is that if there has been some initial confusion by the internet user in this case, initial interest confusion is a doctrine that is considered in certain circumstances when considering trademark infringement. It's a doctrine that came over from the United States but has been applied in a few cases in English law as well. And what it effectively does is it assesses whether when a consumer first sees the use of a trademark in a particular context, whether there is some initial confusion on the part of that consumer, which ultimately is dispelled before they make any purchase, having seen the use of that trademark. In this instance, therefore, what the judge was considering is whether when the internet user first sees the advert, they are confused, but once having clicked on the advert and gone through to the advertiser's website, that confusion has been dispelled, and ultimately there hasn't been any confusion before they've made any purchase. And what he held there was that even that initial interest confusion could be relevant in assessing whether the reasonable internet user test was had not been satisfied by the advertiser in those circumstances. The final thing that the judge held was that he was entitled to consider whether only a significant proportion of internet users that would have seen the Marks and Spencer advert were confused by the Marks and Spencer advert. It didn't necessarily mean that it had to be a majority of the people that saw the advert. As far as he was concerned, as long as it was a significant proportion of those people, that would be enough to establish trademark infringement. As a result of that legal analysis, he made a number of findings against Marks and Spencer. First of all, he held that a significant proportion of internet users wouldn't be able to tell from the ad that Marks and Spencer was not a part of the Interflora network. He held, therefore, that the origin function had been adversely affected by M&S's ads, and so there was trademark infringement. Interestingly, he held that Marks and Spencer had infringed the Interflora trademark both by exact matching on the Interflora keyword, but also by phrase matching and broad matching in circumstances where the Interflora mark was not included within those keywords. And so we come to the appeal now, and first of all, it's just worth considering the grounds of appeal that Marks and Spencer took up to the Court of Appeal. Leave to appeal was given to Marks and Spencer on a number of grounds. I'm not going to go through all of those grounds, but I'm going to probably pick off the ones that are most pertinent to this discussion. The first thing was the reverse burden of proof, which was contentious from the first instance finding. It was the reverse burden of proof placed on Marks and Spencer to prove that their ads satisfied the reasonable internet user test. The second issue was the assessment of the reasonable internet user test by reference to only a significant proportion of internet users. The third issue was the relevance of initial interest confusion to the assessment of infringement. And finally, the issue of infringement by broad matching without negative matching. Taking these grounds of appeal into account, the Court of Appeal, as I mentioned, handed down their judgment in October of this year, and they made a number of significant findings in this particular area of law. The first thing they did is they echoed very strongly what the European Court of Justice had said in saying that there was nothing inherently objectionable in brand bidding to present a competitive offering. They characterised this as fair competition at a very high level. The second thing, which was key to the appeal, was that they did not find that there was a reverse burden of proof. So they effectively said that it was actually for the trademark owner to prove that the advert presented by the advertiser did not satisfy the reasonable internet user test. They also said that there was no rule for initial interest confusion, at least as far as these keyword bidding cases were concerned. Finally, they said that in considering the perceptions and expectations of the reasonable internet user, the judge was entitled to have consideration to whether a significant proportion of the relevant public would be confused by the ad. In terms of the judge's findings on broad match, they generally agreed with what the judge had said there, although they did expand upon what had to be considered in considering infringement in these circumstances. So, first of all, they did find that broad matching generic terms without negative matching a trademark term could be characterised as use of a sign. However, in deciding whether there was use of a sign for trademark infringement purposes, they made it clear that the court had to give consideration to both the object and effect of the advertiser's activities in causing the ad to be triggered by a search term that included the trademark. Even then, they said that even if a court did find that there had been trademark use in those circumstances, they still had to give consideration to the reasonable internet user test to see whether there had actually been trademark infringement as a result of that use. The overall outcome, therefore, was that the judgment was overturned. The Court of Appeal have unusually, in trademark cases, referred this back to the Court of First Instance, the High Court, for it to be retried. So I just wanted to finish with some considerations for both advertisers and trademark owners where they are faced with circumstances of either, in terms of an advertiser, wanting to present ads in relation to people who are searching for some of their competitors, and as far as trademark owners are concerned, where ads are delivered when people are searching using their trademarks. I think the first thing to consider is the trademark that's used in the search term being used by the advertiser in the ad text. If it is, and it's not being used in a way that distinguishes the advertiser's offering from the trademark owner's offering, then that is going to be a concern both for the trademark proprietor and for the advertiser in terms of there being trademark infringement. The second thing to consider is the advertiser's brand being featured prominently. Clearly that needs to be done in order to distinguish the advert. And in considering the use of the advertiser's brand, consideration really needs to be given also to both the reputation, distinctiveness and strength of the advertiser's brand as well. The less distinctive and the less reputation that the advertiser has, the more of an effort that the advertiser probably ought to be making to distinguish his goods and services from the goods and services of the trademark owner, so that it is very clear that the goods and services are not connected with the trademark owner. Against that, consideration does also need to be given to the nature of the trademark owner's business as well. In the event that the advertiser thinks that he does need to make more effort to distinguish his ad from the trademark owner's goods and services in circumstances where his brand may be less distinctive, he needs to give consideration to some of the language he uses in the ad text to really make that distinction. He might want to use wording such as try an alternative to, just to give that clear water between the goods and services he's offering in his ad and those of the trademark owner. The other thing to point out, certainly for advertisers, I think, is to take care when they are broad matching keywords as well. In the event that they start to become aware that the broad match keywords are starting to deliver ads against some of their competitors' keywords, they need to take very, very careful attention to the ad text that is being delivered in those circumstances. And if they aren't confident that their ad text ultimately will distinguish them from the trademark owner, they probably ought to take measures to negative match in those circumstances to ensure that the ad text isn't delivered where the search term does include the trademark owner's trademark. So I'm just going to wrap up now and really, I guess, look to the future. Clearly, one of the key issues as far as paid search is concerned, and brand bidding in particular in the UK is concerned, is what's going to happen in the Interflora versus Marks and Spencer case. I hope by now that actually all of the legal issues have been decided as a result of that case, and so there shouldn't actually be too much concern in terms of any changes in the law as far as this area is concerned, certainly as a result of that case anyway. I'm hoping that that case will now just be decided on its facts, and as a result, people who are looking at brand bidding can have a certain amount of certainty as to what the legal position is concerned at that point. Thanks very much for your time.